It's a real pleasure to be here, and I'm going to make the Snedden appeal and say that what happened was that the government decided to release a bill unexpectedly last week, which has taken over the agenda. So I too am going to change my topic to religious discrimination and religious freedom. And thankfully, what I've prepared to say to you today, even though it involves an analysis of the very same bill that Marcus so ably looked at just that now, the points I'm going to make are complementary to the ones that he made, and I must say that I do agree with all of the points in his analysis. So I'm going to start by obviously reiterating that just last week the government introduced the Religious Discrimination Bill. And this was an implementation of the Religious Freedom Review recommendations, particularly recommendation number 15, which called for enactment of a bill to make it unlawful to discriminate on the basis of a person's religious belief or activity. But notice that recommendation 15 also proposed that consideration be given to providing for appropriate exceptions and exemptions, including for religious bodies, religious schools and charities, in order to protect their religious freedom. So notice that there are two elements: that it should be unlawful to discriminate, and that appropriate exceptions and exemptions should exist to protect religious freedom. Now, this is because religious freedom and religious discrimination are not exactly the same thing, even though they are closely related. And so as a consequence, they cut across each other in certain ways, even though they can also be compatible when they're not overextended against each other. Because a right to religious freedom is a liberty to act on the basis of one's own religion. And this may require discrimination. For example, if a religious organisation needs to ensure that its people adhere to the religion of the organisation in order to protect its religious character. But the exercise of religious freedom in this sense could interfere with someone else's freedom of religion by preventing that person from exercising their religion while employed within the organisation. And so, conversely, when you focus on the proposition that there should be a prohibition on religious discrimination, that means that there's a duty not to treat someone less favourably because of their religion. This may be necessary to protect a person's religious freedom, to enable them to exercise their freedom freely without being treated less favourably because of it, by losing their job, for example. But a prohibition on religious discrimination could also contravene someone's religious freedom by preventing a religious organisation from appointing people of its own religion to maintain its religious ethos. Now, that might seem very abstract and difficult to comprehend, and that's why it's so difficult, because there's a paradox built into the relationship between religious freedom and religious discrimination. And the key thought here is that if the either principle is overextended, it will begin to contradict the other principle, and so they need to be kept within compatible spheres of operation. So let me explain how, as I see it, the Religious Discrimination Bill that we're considering today illustrates this tension. Now, as Mark explained, religious discrimination laws, or discrimination laws generally, consist of four key components. A set of protected attributes, you're not allowed to discriminate on the basis of those. Two ways in which discrimination can occur, direct and indirect, as Mark said, and particular areas of public life in which discrimination is prohibited. And fourthly, a set of exceptions or exemptions designed to permit certain justifiable forms of discrimination. These exceptions or exemptions recognise that the principle of discrimination does not entail an absolute right. Any prohibition on discrimination has to be balanced against other rights, like the right to freedom of religion. And this is where the Exposure Bill gets interesting. The protected attribute, as Mark pointed out, is religious belief or activity, which is defined as holding a religious belief or not holding one, engaging in lawful religious activity or not engaging in it. Notice, and one other point that could be made about this that Mark didn't cover, is that there's no such thing in the bill as a unlawful or lawful religious belief. Now that at least is a good thing. It's extraordinary that the Victorian Equal Opportunity Act refers to the concept of an unlawful religious belief. How that got through Charter of Rights scrutiny, I'll never know. Or how it continues to be there is just not clear at all. But as Mark pointed out, there are some concerns about even the restriction of the freedom and the protection to lawful religious activity. And I won't go into any more about that because I think Mark covered it very well. Mark also well explained the two types of discrimination, direct and indirect, so I won't reiterate what he said about them. But I will note that the protected areas that are covered by the bill include employment and education. They therefore extend to employment in schools and the admission of students, including in religious schools. Now, without any further provision, this would mean that religious schools must not discriminate on the basis of religion when deciding who to employ, as a principal, as a maths teacher, as an administrator, as a gardener. But what if a religious school needs to discriminate in order to maintain its religious ethos? Traditionally, this has been the work of exceptions or exemptions. But one of the objections to the use of exceptions and exemptions in this field is that it suggests that religious organisations are given a right to discriminate. And because the whole purpose of the law is to prohibit discrimination because discrimination is seen as something that should not occur, it casts a negative cast over the whole idea. The Exposure Bill addresses this issue in Clause 10 in a much better way by saying that it is not discrimination if a religious school acts on its religious principles when deciding who to employ or not employ. Notice that Clause 10 turns on several important things. It only applies to religious bodies. The conduct must be in good faith, and the conduct must be in accordance with the doctrines of the religion. Each of these elements, and I think Mark touched on these, raise important questions about the scope and operation of the bill. They are central to the balance that the bill strikes between religious freedom and religious discrimination. I'll come back to these questions in a bit of detail shortly, but before I do, I want to draw your attention to two other important ways in which the bill strikes this balance between religious freedom and religious discrimination. You'll recall that indirect discrimination consists of three elements. There is a requirement or condition laid down an employer with which the employee is required to comply. The requirement or condition disadvantages the employee. And thirdly, the requirement is not reasonable. Several additional provisions in Clause 8 of the bill seek to protect religious freedom by identifying certain circumstances in which such a requirement or condition will be deemed not reasonable and therefore unlawful discrimination. The first of these are clauses 3 and 4, or subclauses 3 and 4. They've been dubbed the Israel Folau clauses, although whether they would protect a person in the position of Folau is not clear. You'll see that they consist of 4 elements. First, there must be a rule of conduct imposed by a relevant employer. Second, the rule must have the effect of restricting or preventing an employee from making a statement of belief. Thirdly, the requirement or condition, even if it restricts the employee's ability to make a statement of religion, will be justified if it is necessary for the employer to avoid unjustifiable financial hardship. And fourth, as Mark pointed out, the statement of belief must not be malicious and must not be likely to harass, vilify, or incite hatred or violence. Each of these elements is important, and I'm going to be saying something about each one of them. But let me first start with section or clause 10, which deals with the ability to protect a religious organisation, particularly a religious school, the ability of that school to protect its religious ethos. The point at the first instance is that there are three different types of religious body that are protected: educational institutions, including schools, registered charities, and other bodies conducted in accordance with religious doctrines. Clause 10, at least at this point of definition, adopts a principled approach to defining religious bodies and institutions. They must be conducted in accordance with the doctrines of a religion. One concern that has been expressed, however, is that registered charities and other bodies are not protected under Clause 10 if they engage solely or primarily in commercial activities. Such an approach runs the risk of drawing too sharp a distinction between religious organisations and commercial activities. Many charitable organisations are expressly religious in their purposes, ethos, and motivation. In order to provide their services to the public, they operate commercially in the sense that they charge fees for their services, but they do so on a not-for-profit basis. It's not obvious that a not-for-profit organisation that is religious in purpose and ethos should not be able to employ staff that adhere to its religious beliefs. As a religious organisation, it wants its services to be offered to the public by employees who wholeheartedly embrace its deepest religious beliefs and motivations. Secondly, religious doctrine and employment policies. Clause 10 enables a religious body to engage in conduct that may be, as Mark emphasised, reasonably be regarded as being in accordance with religious doctrine. Some concerns have been expressed that this will not adequately protect religious organisations, such as schools, in terms of their employment policies. I'd put it this way: the essential problem is the potential for a gap to exist between the employment policies and decisions of a school and the religious doctrines of the school. Because when you think about it, religious doctrines typically involve theological propositions and many other things, including codes of moral conduct, whereas employment policies are concerned with much more mundane matters, such as employment criteria and the particular duties expected of employees. Some religious schools require all their staff to adhere to the religion and conduct themselves in accordance with it, while others prefer to appoint such staff wherever possible, but are willing to appoint others to particular positions sometimes that do not involve a teaching role or a role that involves specifically religious instruction. And here's the point: two schools could adhere to the same doctrinal standards as a matter of theology, but could adopt different policies in relation to the employment of staff. Concerns have been expressed that the wording of Clause 10 does not make clear that all these kinds of schools, all these kinds of policies or decisions will be protected. Does the wording of Clause 10, that an employment decision may reasonably be regarded as being in accordance with religious doctrine, provide sufficient and appropriate protection for religious schools and other religious bodies? And as Mark pointed out, who decides what is reasonable? The words "may reasonably be regarded," in quotes, seem intended to confer on religious bodies a degree of discretion in determining what employment policies and decisions are appropriate and adapted to conducting the organisation in accordance with its religious doctrines. But there remains the question whether the Human Rights Commission, when conciliating complaints, or the courts, when called upon to decide cases, will defer to a school's judgment about what is in accordance with its religious doctrines, or else substituting their own view. This is the kind of problem that arose in the Christian youth camps and Cobor case in Victoria, where the tribunal at first instance and the Court of Appeal of Victoria disagreed with the Christian organisation's own assessment of what its doctrine required. Under the Victorian legislation, the court had to determine whether a decision taken by the organisation, quote, conformed with the doctrines of the religion. Clause 10 of the Exposure Bill doesn't require that the decision must simply conform with doctrine, but does it has to be acknowledged, adopt a more generous standard. that the decision may reasonably be regarded as being in accordance with the doctrine. This could help to resolve the sort of problem that arose in the Cobor case, but it would be better if these matters were made abundantly clear. One way in which the matter could be further clarified is by inserting into the definitions clause of the bill a provision that makes clear the kinds of conduct that will meet the requirements of Clause 10. The definitions could clarify that it will include decisions to employ or engage a particular person or allocate particular duties or responsibilities to a person on the ground that the person adheres to or conducts themselves in accordance with the religious beliefs of the organisation, or some other words calculated to cover those sorts of instances, as well as, on the other hand, decisions not to employ someone or engage a particular person, or to terminate their employment, and so on. A helpful precedent of this kind is found already in federal legislation in the Fair Work Act, section 355. So what about religious statements and what's dealt with in clauses 8, 3 and 4? As I've noted, and as Mark helpfully explained, these protect the freedom of employees to make religious statements outside of working hours. However, the protection is subject to significant constraints. The Exposure Bill defines a relevant employer as a business whose revenue for the current or previous financial year is at least $50 million and which is not a government employer or a public body. These criteria have the merit of being bright line distinctions that are relatively easily applied. However, two concerns have been raised. First, does this definition imply that an employer with a lower turnover is exempt and can therefore control what staff say? Why should that be the case, as Mark pointed out? Secondly, I'd even add, why should government employers enjoy a blanket exemption? This was not the standard that the High Court upheld in its well-publicised recent decision in Comcare and Banerjee. I could expand on that later in questions, if you like. Then, secondly, statement of belief. There's a definition of statement of belief embedded in the clause, and notice that clause 8.3 uses two terms: the religious belief adhered to by the person and the doctrines of the religion. Once again, there is a potential gap here between the religious belief of the individual and the doctrines of the religion. Two individuals may adhere to the same religion, the same denomination. They might even attend the same religious congregation. But they may have conscientiously different views about what they should say publicly and how they should say it. If anything we've learnt from the Israel Folau case, that's the case. A lot of people debate whether he should have said it in the way that he said it, let alone what he said. So the question arises, is the application of a reasonably regarded as test, in this instance as well, able to bridge the gap appropriately? This raises the problem encountered in the New South Wales Wesley Mission case, where the question concerned a provision of the New South Wales Anti-Discrimination Act, which grants an exemption in relation to any act by a body established to propagate religion that, and here's the phrase again, conforms to the doctrines of the religion. The Equal Opportunity Division of the Administrative Decisions Tribunal in New South Wales at first instance held that the relevant religion was that of Christianity as a whole, or alternatively, that of the Uniting Church of Australia as a whole, with the implication that the particular and more conservative theological stance taken by the Wesley Mission was not protected because it could not be shown that what it was doing was in accordance with the doctrines of Christianity or of the Uniting Church. The appeal panel of the tribunal overturned this decision on the basis that the relevant religion should be seen more narrowly and specifically to the particular body engaged in the activity, and therefore, as it described it, the relevant religion was the Wesleyan or Methodist understanding of Christianity. The New South Wales Court of Appeal tended to agree with the appeal panel, although it criticised its approach to some extent as well. So, does the bill avoid this problem? Well, by defining a statement of belief as a statement that may reasonably be regarded as being in accordance with the doctrines of religion could help somewhat, but it still remains necessary to identify the religion in the first place, and that whole question that arose in the New South Wales case could arise again. Fortunately, in my view, on appeal, a better view prevailed, and so I would suggest that the broad approach of the New South Wales Court of Appeal is preferable. It must be the religion of the particular person or organisation involved. Otherwise, the protection of religious freedom will become nugatory. Thirdly, unjustifiable financial hardship. Now, the concern about this is that the protection will not apply if the employer says that it was necessary to place this restriction on the employee to avoid unjustifiable financial hardship. But as some have observed, actually maybe it was me, this may have this seemingly unintended consequence of enabling third-party sponsors to place an employer under financial pressure to control an employer's free speech, as appears to have happened in the Folau case, and that the same kind of pressure or coercion could be exerted through orchestrated social media boycotts, as appears to have occurred in the Cooper's Brewery case that you might remember. Fourthly, vilification and hate speech. As Mark mentioned, Clause 8.4 stipulates that a statement of belief will not be protected if it is malicious, if it's likely to harass, vilify or incite hatred or violence, or encourages conduct that would constitute a serious offence, such as, again, physical violence. Some aspects of this clause are clearly very appropriate. Inciting violence surely can't be something that we would regard with equanimity. However, other aspects arguably place too much of a restriction on free speech, as Mark pointed out. But I want to go a little further on that point. To explain why this might be the case, some context is necessary. The exposure draft in Clause 41 goes so far as to provide that a statement of belief does not contravene Section 17 of the Tasmanian Anti-Discrimination Act. This Tasmanian law imposes what is probably the most restrictive prohibition on free speech in the country. It prohibits engagement in any conduct, including any speech, which offends, humiliates, intimidates, insults or ridicules another person on the basis of a protected attribute. Thus, speech which merely offends is illegal in Tasmania in these terms. There are other laws in Australia that place significant restrictions on speech. Section 18C of the Racial Discrimination Act prohibits any public act which is reasonably likely to offend, insult, humiliate or intimidate another person or group of persons on the basis of race. And several other state vilification laws, as Mark pointed out, prohibit the incitement of hatred, serious contempt or severe ridicule on the basis of race or religion. And again, some of these restrictions are directed at speech that is quite abhorrent, but the restriction is very broad, particularly when the causing of offence is made illegal. Section 41 of the Exposure Bill does not have any impact in any of these latter provisions of Commonwealth and state laws. Indeed, the Exposure Bill imposes its own implicit restriction on free speech, as Mark pointed out, to the extent that it allows an employer to control the speech of an employee if it would, quote, vilify another person or groups of people. In this whole area of the law, over time, there's been an inflation in the concept of hate speech. However, the leading international human rights instrument, the International Covenant on Civil and Political Rights, in Article 20.2 defines hate speech very carefully and specifically. There are 3 elements to its definition, all of which have to be satisfied. First, there must be advocacy of national, religious or religious hatred. Secondly, the advocacy must constitute incitement to the commission of particular conduct. And thirdly, the incited conduct is specified as discrimination, hostility, or violence. The various state, territory and Commonwealth laws I've referred to are not limited in the way required by the International Covenant. In some cases, they prohibit conduct that merely offends someone on the basis of a protected attribute. The exposure draft itself merely refers to conduct that vilifies without further definition or clarification of its meaning. A high-level meeting of international human rights experts convened by the United Nations Commissioner for Human Rights concluded in its 2013 report that Article 20.2 of the International Covenant deliberately establishes what they called a, quote, high threshold for the restriction of free speech, precisely because, quote, as a matter of fundamental principle, limitation of speech must remain an exception. While Article 20.2 calls for the prohibition of hate speech, carefully and narrowly defined, it must also be read with Article 19 of the International Covenant, which calls for the protection of freedom of expression, and requires that it can only be restricted by measures that are necessary in the sorts of terms that Mark identified in his paper, necessary to protect the rights or reputations of others. The United Nations experts' report that I've referred to stated that when Articles 19 and 20.2 are read together, they require that any restriction on hate speech must be, quote, carefully and narrowly defined. Secondly, quote, the least intrusive means to achieve its objective. Quote, not overly broad. Quote, proportionate, and must accord closely with the precise language of Article 20.2. The UN expert report expressed concerns about the use of increasingly vague terms to define hate speech offences and the development of new categories of restrictions, and noted that the broader the definition, the more it opens the door for arbitrary application of the law. The expert report also reflected on the relationship between freedom of religion and freedom of speech in the following terms, and I quote, the freedom to exercise one's religion or belief cannot exist if freedom of expression is not respected, as free public discourse depends on respect for the diversity of convictions which people may have. And I continue the quote, likewise, freedom of expression is essential to creating an environment in which constructive discussion about religious matters can be held. Indeed, free and critical thinking in open debate is the soundest way to probe whether religious interpretations adhere to or distort the original values that underpin religious belief. So there's reason to be concerned in my submission that Australia may be in breach of its international obligations to protect freedom of expression and freedom of religion through vaguely defined and excessively broad restrictions on what is described as hate speech. And so in conclusion, like Mark, I think that the Religious Discrimination Bill is, on the whole, a good start. Indeed, to an extent, it is a careful and nuanced attempt to implement the recommendations of the Religious Freedom Review. In drafting such a law, it's inevitable that tensions will arise between the protection of religious freedom and the prohibition of religious discrimination. The two principles are distinct but closely related. In many contexts, they can be mutually reinforcing. It is only when one or the other principle is overextended that conflicts can arise. The Religious Discrimination Bill gives careful attention to this problem in several ways. It's an admirable first step, but as the Attorney-General understandably anticipates, various adjustments will be required. In my view, many of these will be in the form of clarifications to ensure that the bill achieves what it is intended to achieve. Thank you.